Hello, my name is Bill Hanley, and I'm the chair of the Risk Management Committee for the New Jersey Realtors. In an effort to provide a contract that satisfies all of our members, a task force was comprised of members of the Risk Management Committee, and they revised the New Jersey Realtors contract of sale based on our members' suggestions. Please note at this point that this is not a mandated form, but this is something that we are encouraging everyone to use throughout the state. I'd like to thank the task force for their diligent, detailed work that's resulted in a universal contract that also incorporates the TRID changes, which will go into effect on October 3rd. In addition, the short sale addendum and rider to real estate sales contract for the new construction have also been updated in conjunction with the contract of sale. As a member, you have free access to the new contract of sale, and I strongly urge you to use this as the default contract. To review the substantive changes of the form, New Jersey Realtors Legal Counsel Barry Goodman is going to take it from here.
My pleasure. I will tell you, the sales contract has been substantially revised. A lot of paragraphs have been moved around to try to group them together. Some paragraphs have been rewritten. We've added in new provisions. So I'm going to attempt to go through right now the main changes. I'm not going to try to deal with every word that's been changed because I encourage all of you, read the contract, read it carefully, make sure you're comfortable with it. I'm just going to try to give you a little bit of an orientation so that when you look at the contract, you'll have a sense of what the changes already are, the major changes. Now, let's start right up front on the first page. As you all know, the cover page of the contract has to be the Opinion 26 notice. That was slightly revised, and we included at the bottom a signature place for the listing broker, the listing agent, who will now be able to sign it, and also a spot that will say prepared by. It just seemed to make sense because the first paragraph, it talks about as a real estate broker, I represent, and then there are places to check off who you represent, the seller, not the buyer, not the seller. And it made sense to state who actually prepared the Opinion 26 notice, so that way everybody will know so it doesn't get confusing. Small change, but I just wanted to alert you to it so you don't go flying by the Opinion 26 notice. Now, the first page of the contract itself is going to look very different. Right below the attorney review language, which is mandated by the Supreme Court, New Jersey Supreme Court, it has to be at the top of the first page of the contract. We inserted the table of contents. We figured it just made more sense to have it in the front instead of the back. That way, when you look at the contract and you need to find something, or the buyer or seller needs to find something in it, they can do it a lot easier because the table of contents is right there. The second section of the contract is essentially the same. The parties and the property description, we changed a couple of words here and there, but it's essentially the same. One other thing that we moved to the front, and actually we added to the front page, is a breakdown of the purchase price. We decided that it made sense to have right there where you have the property description, how the purchase price is broken down. So you'll see in section 2, it'll say total purchase price, initial deposit, additional deposit, mortgage, and balance of purchase price, so you know how much has to be brought to the closing of the settlement. So we thought that made sense to have the property, parties, and the financial information right there on the first page. So that's going to be a little bit of a change, different format, and we think it works nicely. Now, moving over to the second page. One issue that came up was with the initial deposit. The old contract said that you as the agent had and when I say the agent, I'm talking about the buyer's agent, because it said, on signing this contract, you have the initial deposit. Well, that's a representation to the seller and the seller's agent that you had the deposit in hand. And very often you might not. It might be that the buyer said, I'm going to get you that initial deposit in a couple of days, we've got to get that offer in. It might have been that it's an electronic signature situation where your buyer is in Toronto or California or wherever, and so you don't have that initial deposit, but you have to get the offer in. So we took out that language on signing this agreement. It was also something I can tell you that the Real Estate Commission was troubled by if you didn't have that deposit and were making that representation that you had it. So we changed it, and we said that we put in a date that you'll have the initial deposit on or before blank date. So you'll have to fill in a date right there. And the date can be, whatever date you think is reasonable. I've heard people say, 5 days after the contract is signed, 2 weeks, whatever, but you're going to have to fill in a date. We also added in as to who is going to hold that initial deposit, that it can be held not only by the listing broker or participating broker, which is in the old contract, but it can be held by the buyer's attorney or the title company, which I think increasingly will be handling a lot of these closings, these settlements in the future as a result of the new regulations that are going into effect on October 3. And we also put in a place for other, just in case there was some other scenario. Because I know that a lot of brokers no longer want to hold the deposit, whether it's the initial deposit or the second deposit. They don't want to be bothered with it, and they'd rather have whoever's going to close title hold on to that deposit, which I think makes sense. But we left the options open and added boxes for you to check off or to add other. Moving down on the second page, Section D says if performance by buyer is contingent upon obtaining a mortgage, the mortgage contingency section. It used to be that in this section, what we did was we revised the attorney review language that's in there. And we did this throughout the contract. It used to be that the contract said that you had to apply for the mortgage, shall I say, within 10 calendar days. And it said after attorney review. Now you can see throughout the contract that language after attorney review has been modified. Why? Because after attorney review, for those of you familiar with the unauthorized practice of law cases, and specifically the Supreme Court's mandate on attorney review, it said there's 3 business days for attorney review. After the 3 business days, attorney review is over, unless the attorneys agree to extend it. More often than not, though, what would happen is the attorneys would disapprove the contract within 3 business days. Once one of the attorneys for the buyer or seller disapproved the contract, attorney review is over, and there technically is no contract. So we changed the language instead of saying after attorney review, to say that it would be within a certain period of time, in this case within 10 calendar days, after the attorney review period is completed, or if this contract is timely disapproved by an attorney, as provided by the attorney review section of this contract, then within 10 calendar days after the parties agreed to the terms of this contract. Excuse me. We felt that made more sense. It actually was, more descriptive. And there was certainly no reason to be applying for a mortgage if you don't have a contract that's been agreed upon at that point. There's no valid contract in effect. So you'll see that throughout, and I wanted to just explain why we did that change. In that same section, the old contract provided that if the buyer didn't get the mortgage contingency within whatever period of time was filled in, then the buyer or the seller could void the contract. It was automatic at that point. Now we've changed it so that there's a procedure set forth in that paragraph so that period for the mortgage commitment can be extended. Because all too often, through no fault of the buyer, they don't get the mortgage commitment on time. So we've included a procedure there that I'd encourage you to read. We added in that, still on the second page, in that same section, a section for FHA and VA loans, in case the buyer is applying for one of those. And you'll see right there, this is the first time it appears in the agreement, there are boxes to be checked off. It says applicable, not applicable. We've included that in lots of different sections, so you're going to have to check off and go through whether or not these different sections are applicable or not applicable. And this is the first one. Whether or not it's an FHA, VA loan, just check it off. If it's applicable, fine, you move on. But I just wanted to point that out to you. We also included, the next section is that a buyer property sale contingency. It hadn't been in the contract before, but it comes up all too often. And we thought, why not put it in the contract? We tried to eliminate some of the addendums that become necessary during the course of these transactions. So we included a provision right there in terms of if the buyer has to sell their house and what the procedures are going to be. buyer providing a contract of sale if there is one. If the house is not listed yet, buyer listing it with a licensed broker. What happens thereafter, the notices that have to be provided, and what the seller's rights are in that section in case the buyer doesn't come up with somebody to purchase the house that they're selling, and they need to sell in order to buy the house in this contract. Next, we added in a provision concerning accurate disclosure of the selling price, just to parties should confirm that that the amount set forth in the contract is accurate. The next thing on page 3, section 9, and this is the time of the essence provision. This is one of those situations that I'll tell you, certainly in South Jersey, they've been living with time of the essence for a long, long time. Most contracts in North Jersey haven't had it. And so this became an issue, and I will tell you the task force discussed it very thoroughly because we recognized that some people might be a little uncomfortable with it. But at the end of the day, I can assure you that around the rest of the country, time of the essence is a standard clause. South Jersey, it's a standard clause. And it can always be changed. During attorney review, attorneys can change it if they so desire, and quite frankly, what I have found is that it's really only the attorneys who want to change it because everybody else wants to keep things on track. Buyer and seller want to have certainty when I'm going to close. Realtors want to have certainty when I'm going to close. And so it's the attorneys, because they may not be available on a closing date. They may have other things they want to do that sometimes get a little nervous about time of the essence. All I can say is that it works. Give it a chance. And one other thing. With the new regulations that are going into effect on October 3, I fully expect there's going to be a little bit of confusion that's going to happen. But I think after a few months, things will settle down. Everybody will become very comfortable with the new regulations that are going into effect. So what we did was we included in the time of essence provision that if a closing has to be delayed because of the new regulations that were promulgated by the Consumer Financial Protection Bureau, that's okay. That'll be an exception to the time of the essence because we recognize that may occasionally happen, and there are certain rules that were put out by the Consumer Financial Protection Bureau that would require certain closings to be delayed. For example, if the loan product is changed, or if the interest rate goes up more than an 8%, or if they add a prepayment penalty at the last minute for the consumer, the closing gets put off. But let's remember, those are the only 3 things, and I'm not going to go into a seminar on the new regulations. But the long and the short of it is we've included provision for that right here to take into consideration. Next section, section 10, we rewrote the certificate of occupancy and zoning compliance. And I just want to point out in this section that it used to be that it specified the seller would agree to pay to bring the house, the property, into compliance if there was any issue. We've included a cap now. So it's not unlimited, because a lot of sellers felt it was unfair. They might decide not to sell the house if the cost to bring it into compliance was too high. So there's a cap. And if the cost to bring it into compliance is above that cap, and it's an amount that you have to fill in, then the parties can try to work out something. If they can't, they can void the agreement, but there's provision as to how to work that out. Next is a section that was added in terms of condominium, homeowners association, certain documents, assessments that have to be disclosed right in the sales contract. We heard from so many people that that's just information that you really need. In fact, it's critical to a decision of a buyer to know what assessments are coming down the road if a homeowners association is involved. And once again, that's one of those you check off: applicable, not applicable. If it's a private home, it doesn't apply, and you just move on. Let's see. Next one I'm going to point out. We revised the section, I'm now on section 15, on New Jersey Hotel and Multiple Dwelling Health and Safety Act. And we simply revised it to say that the seller is going to supply the buyer with a validated certificate of registration and a certificate of inspection that's been issued by the New Jersey Department of Consumer Affairs. That typically happens. It should happen. It's supposed to happen. And so we felt, let's spell it out in the contract so that there's no question about it. You don't need to add an addendum or write it in additional provisions at the end. The next section is lead-based paint. We added in a section right there concerning a lead warning statement, you'll see. That was not in there before. And that's something that's required by federal law, so we really had no choice but to insert it into the contract. So we did. It's just a warning to the buyer about the buyer's rights. Okay, next section I'm going to do is section 23. Airport safety and zoning notice. Now, I heard a chuckle over here from Bill because I'm going to tell you that most of the realtors around the state that I've talked to lately don't even know about this airport safety and zoning notice. I went to one seminar and I asked a group of about 100 people, how many of you have ever given a notice under the Airport Safety and Zoning Act? And out of that group, 3 people raised their hand. I'm going to tell you that under the Airport Safety and Zoning Act, there is a requirement for the seller and for the real estate broker who is representing the seller to advise a buyer if the property is located in a municipality that is governed by the Airport Safety and Zoning Act. Now, we identified 52 municipalities that are affected by the Act. We've listed them right there in the contract for you. We've listed the airport that it applies to. And just so that you understand, typically we're dealing with the municipality where the takeoffs at the airport would take place or the landings. And the municipalities are required actually to pass ordinances that would deal with the act, and so that you can't have buildings that are too tall or trees that are too tall or towers that are erected right where the planes are going to take off or land. That's really the purpose of it. But you need to take a look at the list. And if you're selling property in one of those municipalities, you have to tell that buyer, go to the municipal clerk, see if there are any ordinances that affect your property. That's a requirement. And the statute is very clear because the statute refers to real estate licensees and says, if you don't do that, you might be sanctioned as a licensee by the Real Estate Commission. It's one of the few statutes I've ever seen that actually specifically refers to an obligation on the part of the real estate licensee to do that.
This is something you should really do at the time you're taking a listing. Don't wait until a contract comes in and then everybody starts to scramble because it's only going to put everything off. So when you take a listing, you should review these and be sure that you mark it in your listing if it is something that's there.
Absolutely, yes. Now, I'm also going to tell you the municipalities have an obligation to notify the owners of all the properties that were affected by this in the municipality. But unfortunately, that notice may have gone to the person who owned the house, 3 owners ago. And so the present owner may not know about this ordinance, this requirement to disclose. So you have to be very careful. Now, one other thing I just want to mention in terms of this issue. You're going to look at the list and you're going to see a couple of glaring omissions, if you will, in terms of some airports that are on there. And I'm going to read you a quick list now so that the Essex County Airport, Linden Airport, Newark Liberty, Teterboro, Little Ferry Seaplane Base, Atlantic City International, McGuire Air Force Base, and Lakehurst. None of those are on the list because the list only deals with airports that are governed by the New Jersey Department of Transportation. These other airports are governed by other entities, like Port Authority and the like. So they're not on the list, they're not affected. And so no notice has to be given about those airports. Let's move over to section 28, which we added in. It's a provision that deals with initial and final walkthroughs. Now, historically, there usually is one walkthrough. That's the morning of the closing, a final walkthrough to make sure that everything is in order. Because of the new regulations going into effect on October 3, that require a lender to get the closing documents to the consumer at least 3 business days before the closing, which means that if they're going to mail it, they have to do it at least 3 business days before the closing. All the information about issues, financial issues and such, are supposed to get to the lender in a timely fashion so that the lender can prepare the closing documents and the closing can go smoothly. But there can be financial changes at the closing. You know, if something's discovered in the final walkthroughs, you can still make changes, and that's okay. You don't have to delay the closing. But you still have to try to get that information to the lender, and it'll make the closing go that much smoother. So what we've provided for, and what I think is going to probably become the norm, is to have 2 walkthroughs. One about 10 days before the closing or settlement is scheduled, and the other the day of the closing. So that way, after the walkthrough that's 10 days before the closing, you'll be able to get the information from the lender if any adjustments have to be made. And it'll make life just much easier at the closing. So we've included a provision about that. Next thing I want to touch on is the section on brokers' information and commission. You'll see additional information in there that was not in the contract before. For example, you're now going to see a requirement that you include in the contract of sale the agent's real estate commission license identification number, the broker's real estate commission license identification number. That information is required under the new regulations, the CFPB regulations that go into effect October 3. The new closing documents must contain that information, the theory being that if they need to get a hold of the real estate agent or the broker that was involved in the transaction, having that identification number will make it easier. So it's required. The lender has to have that. So we said, let's just include it right up front in the sales contract. It just makes sense, make people's lives easier. We also added in section 34, a provision that concerning whether or not the buyer or the seller is a real estate licensee. The reason we added this is all too often I have seen where it is not disclosed. As you know, Section 17, or should know, Section 17 of the Licensing Act requires that you disclose if you have an interest as the buyer or seller in the transaction. If you don't, you can be sanctioned by the Real Estate Commission. And all too often we saw contracts where people forgot to include that. Realtors forgot to include that. So we just said, you know what, let's just put a provision in here. We also added in a provision, that's section 35, that the brokers are to receive the closing disclosure documents that are prepared by the lender under the new rules. We did that because the new rules are pretty clear that unless there is authority for the lender to release the closing documents to the broker, that the lender could take the position that the information is confidential and they can't share it. I think in most situations it makes sense for the brokers to have it so they can see what's happening, make sure that they don't see any problem with it. And so we included a provision right here where the buyer and seller are agreeing that the lender can and should provide the closing documents to the brokers in the same manner at the same time as they do to the consumers, so that you stay in the loop. The next provision we had, section 36, professional referrals. This is over the years has certainly been the source of a lot of litigation, so we're hoping to kind of head it off a little bit by including a provision in here that says you are referring them to people, but they have to make their own choices. You're not responsible for those choices, they're responsible for those choices. So the hope is that they understand that they have to own their own choice, that you're not the one, you're not dictating that they go to a professional. And that's one of the reasons why you always have to give at least 3 professionals when you recommend professionals and let them choose. And so this paragraph hopefully will dissuade people from filing lawsuits in terms of referrals to professionals. And certainly will be a defense if there is a lawsuit. Next section I want to just mention is section 38, notices. For those of you who have read the old contract recently, you will see that there are very few options in terms of how notices are to be provided. It was certified mail, fax, or telegram. I don't know how many of you have sent out telegrams lately. I know I haven't. So we deleted telegram. And what we did, we updated it and we added in notices can be sent by email, recognized overnight courier, or electronic signatures. Just to kind of bring us current in terms of notices. This is not an issue. Next, we added in a provision, section 40, electronic signatures and documents. Under the federal law and under New Jersey law, electronic signatures are permitted. I still have attorneys who say, no, I'm not going to accept an electronic signature, because I want an original, I want a wet copy. It's not required. The law allows it, electronic signatures, and some people just don't understand that. So let's just put it in here, put people on notice as to what the law is, so that hopefully people will come, into the modern age and allow for electronic signatures instead of requiring original signatures. On the last page of the contract, if you remember, where the buyer and seller sign, there's a witness portion of it. And when you're dealing with electronic signatures, there's nobody there to witness it. But you do have verification under electronic signatures. I don't care what system you're using, they all have it. Verify that this, the person who's signing is the right person. And so that kind of replaces the witnessing section. So if you're using electronic signatures, don't worry. You don't have to have a witness to the contract. The signature itself is good enough. Okay, so we include a sentence just alerting everybody to that fact, because I didn't want there to be a problem later on if some attorney tries to question you. Gee, I can't accept this, it's not witnessed. Doesn't have to be if it's an electronic signature. We also added in section 41 a provision that says if it's a corporate entity that is buying or selling the property, all corporate resolutions have been properly done, so that way you're protected. And that brings us to the end of the contract. The only other thing that I'm going to mention is that New Jersey Realtors also is going to be putting on the website when the contract goes up, and hopefully, if you're looking at this after it's gone up, a timeline of all of the different provisions that require you, or for that matter, an attorney or the title company, to do something in the sales contract. It's almost like a roadmap, and it'll lay out for you, all the issues that there's a timing element for, and you can fill in the date and then keep track to make sure that you don't miss something that has to be done in the contract. And so it lists attorney review, the periods, deposits, and when they have to be taken, section on condominium owners associations, leases, when they have to be delivered, lead-based paint, in terms of the notice for lead-based paint, private wells, cesspools, radon, inspections, when they have to be completed, flood hazard area, what has to be done there, the timing of it, mortgage contingency, it lists the different things that have to be done. Buyer's property sales contingency, it lists the dates that the buyer has to act. Title exceptions, walkthroughs, the 2 walkthroughs we talked about, one about 10 days before the closing, the one date of the closing, closing documents, when they have to be in the hands of the consumer, and then finally it finishes up with what's the closing date. So it has all the relevant dates listed there to help you to organize yourself, to make sure you're on top of it, whether you're doing it or not. I think it'll be helpful for you. I think that kind of closes it. I think we've covered everything. Bill, I don't know if you have anything else.
Actually, I just want to thank you for doing this with us today, and to let everybody know, we understand that change is difficult for everybody. And we've been through a lot of changes. The longer you've been in the business, the longer the amount of changes are. And in time, we get used to it, we understand what it is, and it just becomes a matter of course with the business. That's what's going to happen here also. There'll be a little bit of a learning curve, but in the end, you'll get it.